A very warm welcome to everyone. Today, I, Reeya, am here virtually as a legal intern of LEXIS and Company to explain the topic Termination of Services of Temporary Government Servant. In the previous video, we understood who is a temporary government. Further, we also understood the main features of the Central Civil Services Temporary Service Rules 1965. Further, I explained the right to employment with respect to the Golden Triangle Rule of Article 14, Article 16, and Article 21 of the Constitution of India. Now, in this particular video, we will understand certain important case laws. The first case law is Commodore Commanding Southern Naval Area Kochi versus V.N. Raj. The facts of this particular case are that the respondent in the first instance was appointed as a casual laborer for the month, but was continued against an existing vacancy. He was later appointed as a laborer in a regular cadre in an existing vacancy. Sometime later, he was promoted and appointed as ammunition repair laborer grade 2. 3 years thereafter, his services were terminated. Now, the issue in this particular case is whether the termination of services of the respondent who was appointed to the post of ammunition repair labor grade 2, ARL grade 2, when juniors were retained in service was discriminatory and was in contravention of Article 16 of the Constitution. The particular court held that the respondent was only a temporary government servant and that even as a temporary government servant, he is entitled to the protection of Article 311 Clause 2 of the Constitution, where termination involves a stigma or amounts to punishment. The decision to terminate the services of the respondent had been taken at the highest level on the ground of unsuitability of the respondent in relation to the post held by him, and it is not by the way of any punishment and no stigma is attached to the respondent by reason of the termination of service. In these circumstances, the appeal is allowed and the judgment of the High Court is set aside. The appellant's order terminating the service of the respondent is confirmed. The next particular case is Parshottam Lal Dhingra versus Union of India. The facts of this particular case are that in August 1924, the appellant joined the railway service as a signaller telegraphist. As a result of selection, he was promoted as section controller in 1942 and as deputy chief controller in 1947 and as the chief controller in 1950. All these posts were in class 3 service. On March 31, 1951, 7 candidates, including the appellant, appeared before a selection board constituted for selecting a candidate for the post of Assistant Superintendent Railway Telegraphs, which was a gazetted post in Class 11 officers cadre. The appellant was selected out of 7 candidates for this post. On July 2, 1951, a notice of appointment was issued from the headquarters of the East Punjab Railway, Delhi, notifying, I quote, Mr. Parshottam Lal, officiating chief controller, is appointed to officiate in class 2 service as assistant superintendent railway telegraphs. Headquarters office vice Mr. Sahu Ram, whose term of temporary re-employment expires on the afternoon of 3rd July 1951, unquote. The applicant actually relieved Mr. Sahu Ram in the afternoon of July 3, 1951. It appears that on April 28, 1953, one Gauri Shankar, SSTEI, made certain adverse remarks against the appellant in his confidential report for the year ending March 31, 1953. This confidential report came before Shri S. Sain, CSTE, on May 25, 1953, who confirmed the views expressed by Shri Gauri Shankar and added his own opinion, which was also adverse to the appellant. According to the usual practice obtaining in the office, the aforesaid remarks were placed before the general manager, Shri Karnal Singh, who on June 11, 1953, remarked thereon as follows, I quote, I am disappointed to read these reports. He should revert as a subordinate till he makes good the shortcomings noticed in this chance of his as an officer. Portions underlined read to be communicated, unquote. In this particular case, the Supreme Court has laid down two tests to determine whether the termination is by way of punishment. Number one, whether the servant had a right to hold the post on the rank. Number two, whether he had been visited with evil consequences. If a government servant had a right to hold the post or rank, either under the terms of any contract of service or under any rule governing the service, then the termination of his service or reduction in rank amounts to a punishment, and he will be entitled to the protection of Article 311. The Supreme Court held that the appellant had no right to the post as he was merely officiating in the post, and the implied term of such appointment was that it was terminable at any time on reasonable notice by the government. The appellant was not reduced in rank by way of punishment, and therefore he cannot claim the protection of Article 311 Clause 2. In a case where a government servant has no right to hold the post or rank, his termination from service or reversion does not amount to punishment, since it does not forfeit any right of the servant to hold the post or rank, as he never had the right. The next case and the last case that we shall be talking about in this particular issue is Yadav Krishna Mohan versus Union of India. A division bench of Ajay Kumar Tripathi and Neelu Agarwal Justice dismissed an appeal filed for the wrong exercise of powers by the DIG CRPF under Rule 5 Clause 1 of the Central Civil Services Temporary Service Rule 1965. The facts of this particular case are that the appellant was dispensed from the services after giving 1 month's notice under Rule 5 Clause 1 of the Central Civil Service Temporary Service Rule 1965 by the DIG CRPF. The appellant was said to have not completed the training, due to which he did not acquire the status of a permanent government servant, which eventually turned down the claim for wrong exercise of power under Rule 5 Clause 1 as mentioned above. One of the arguments was made that during the course of training itself, the appellant had suffered injuries which made him incapable of performing his duties. Therefore, the appellant should have been protected under the Persons with Disability, Equal Opportunity, Protection of Rights and Full Participation Act 1995. In this particular case, the court held that the applicability of the Act carries few exemptions in regard to certain organizations and establishments, which include the paramilitary force. Further, the question of alternative employment remains invalid as the appellant had not acquired the permanent status. The appeal was dismissed on the grounds stated above. I would like to conclude this particular video by saying that Article 311 Clause 2 of the Constitution does not in terms say that the protection of that article applies only to persons who are permanent members of the services or those who hold permanent civil post. To limit the operation of the protective provision of this article to the permanent government servants alone would amount to adding of qualifying words to the article. The protection afforded by that article applies equally to persons in permanent appointment as well as to those appointed on temporary basis. It is a well-settled law that the services of a person appointed on a temporary basis in the service of the state is liable to be terminated in the exigencies of public service by ordering termination in accordance with rules regulating temporary government servants. And to such termination provisions of Article 311 Clause 2 does not apply, because such termination is neither dismissal nor removal within the meaning of Article 311 Clause 2. Thank you so much.